such contention, reliance is placed on the decision-based decision of the court in the case of Upanando Chatterjee versus State of West Bengal, reported in 2007 4CHN 605. The notice dated 6 March 2025 notifies only the dates of counseling. It has no nexus with the post-counseling deployment. Effect of it starts and ends with the counseling. The choice exercised by the petitioner at the time of counseling cannot override the discretion exercised by the state in deploying the petitioner to meet the administrative exigencies and public interest. No cogent case has been made out as to why individual preference of the petitioner for a particular college and his inter-C merit ranking should carry greater sanctity than the administrative discretion of the state. Mere dissatisfaction with the place of posting by itself cannot be equated with the prejudice, legal prejudice. The phrase, if offered to me, appearing in the self-declaration of the petitioner, clearly indicates that the contemporaneous understanding between the parties has always been that there is no guarantee of an offer of deployment as per the choice exercised by the petitioner during counseling. Such choice is merely an option and does not become binding unless it is offered. The allegation under contention of the state made in its affidavit in opposition are deemed to have been admitted as no reply to the said affidavit has been filed by the petitioner. On the point of doctrine of non-traverse, reliance is placed on the decision of the Honorable Supreme Court in the case of Lohia Properties Private Limited, Tinsukia versus Atmaram Kumar, reported in 1993, 4 Supreme Court cases, page 6. The petitioner, for the absence of specific allegation in the pleadings, not only has failed to make out a case of mala fide, but also is not entitled to set up such a case without impleading person against whom the allegation of mala fide has been sought to be levelled. On this point, reliance is placed on the decision of the Honorable Court in the case of Ratnagiri Gas and Power Private Limited versus RDS Projects Private Limited, reported in 2013, 1 Supreme Court cases, 5-4. The case of William Vincent Vetterelli Supra need not be referred to even. No doubt, it is the obligation of the state to follow the principle laid down in the said decision, but the SOP does not confer any enforceable right upon the petitioner, and when there is no right, there is no question of discrimination or violation of Article 14 arises. Besides, in the said case, the legality of discharge of an employee in public employment was under consideration. In the first round of present proceeding, it has already been decided that the petitioner is not under public employment. Therefore, the principle laid down in the aforesaid judgment has no manner of application in the present case. The SOP, merely an executive instruction, cannot be equated with the rules and regulation formulated by the authorities under Article 212 of the Constitution. For this reason, the Constitution bench of this Honorable Supreme Court in the case Sukhdev Singh is not applicable. In the absence of statutory rule, state in exercise of its executive power can issue administrative instruction. Such executive actions, being gap-filling exercise, lack the force of law. On this score, the decision in the case of Dr. Amarjit Singh Ahluwalia is not relevant to the issue under consideration. Ramanna Dayaram Setti is a case emanating from notice inviting tender where certain relaxation was granted which was challenged. The Honorable Supreme Court, though, has considered the principle of laid down in the case of William Vincent Vittorelli, but ultimately no relief was granted. Similarly, in the case of Dasjit Singh Griwal, the case of William Vincent Vittorelli, though, was considered, but no relief was ultimately granted. The case of Param Singh Supra is also not applicable in the present case, inasmuch as in the said case it has been held that unless there is a statutory scheme, non-statutory guidelines cannot be enforced. The case of Bhavna Tiyari is also misplaced in the facts and circumstances of the present case, as the said case relates to admission in medical college and allegation was large-scale blocking of seats. In the backdrop of such fact, the Honorable Supreme Court has made the observation regarding the counseling. In the present case, the petitioner has no grievance against counseling. The decision in the case of B.S. Minhas Supra is not applicable in the present case inasmuch as the said case relates to employment in the body governed by statute. The decision in a case of Asha is also not applicable in the present case for the simple reason that the said decision pertains to adherence to a settled protocol in the process of selection of grant of admission. But in the present case, in the said SOP nowhere provides that the deployment is to be made according to the merit and preference exercised by the candidate at the time of counseling. Reply of Mr. Dhar. The SOP does not merely say counseling, but it clarifies that it should be counseling based on merit. It is preposterous to suggest that memo dated March 6, 2025 has got no relation with post-counseling deployment, and that fact of it starts that the effect of it starts and ends with counseling, inasmuch as a plain reading of the said memo would indicate that the counseling is also for the purpose of engagement. It is not a correct interpretation of the interpretation that the phrase "if offered to me" appearing in the self-declaration as required to be given by a candidate in terms of the aforementioned memo gives a discretion to the state to assign posting to any candidate in any place according to its choice. The correct interpretation of said phrase is that choice must commensurate with the rank. In other words, unless a candidate gets a rank befitting to his choice, he cannot have a right to get posting to the chosen establishment. Departure from it can only happen when the candidates fail to register himself within the time stipulated under the memo dated 4th March 2025. And in that event, department has the discretion to assign posting of a candidate in the remaining vacant seats after counseling. The facts of the case are not in dispute. The interpretation of the nature of the SOP and its binding effect are the issues under consideration, which are fundamentally pure questions of law, not dependent on the affidavit of the parties. Therefore, the doctrine of non-traverse has no manner of application in the present case. The petitioner has not alleged malafide of any authority or person. Therefore, the argument of the state on this score and the decision in the case of Ratnagiri are completely irrelevant. The decision of Lohia Properties relates to Order 8 Rule 5.1 of the Code of Civil Procedure, which clearly says fact. The said decision has no nexus with the issue under consideration, inasmuch as facts of the present matter, which ranking of the petitioner, vacancy, existence of SOP have not been disputed by the state. In the case of Chief Commercial Manager Supra, an existing statute and corresponding executive instruction were compared. The said decision has no application in the present matter inasmuch as no separate statute is under consideration here. In the case of R. Sai Bharati Supra, is a matter arising out of a criminal appeal where the code of conduct of the chief minister was under consideration. As such, is not relevant to the present matter. The case of S. L. Abbas Supra lays down the proposition of transfer in service jurisprudence, which is completely irrelevant to the issue under consideration. The division bench decision of Upananda Chatterjee is misplaced in the facts and circumstances of the case inasmuch as the said decision relates to removal of the pradhan and service of notice, which is purely procedural in nature, whereas the present case, the sanctity of the SOP and the applicability of Article 14 of the Constitution are the relevant issues. The argument of learned Advocate General that Ramanna Daram Sethi and in the case of Darshit Singh Griwal cannot be relied on by the petitioner as no relief was ultimately granted in the said two decision is not correct inasmuch as the Honorable Supreme Court in the said cases, though has laid down rules inviting arbitrary action of in exercise of discretion, but has denied relief to the party only to on the ground of delay, which is not a case here. Now the court hard learned counsel for the parties peruse the materials on record. The state has sought to justify the posting of petitioner to Raiganj Medical College Hospital, Uttar Dinajpur, by ignoring the choice exercised by him during counseling on the ground that SOP is an administrative instruction having no force of law, list of a regulation. List of a regulation. As such, state is not bound to follow it. As the said procedure does not confer any right, therefore it is not enforceable. The state action is under challenge. To decide the sustainability of the said challenge, at first it is necessary to introspect the scope of judicial review to such administrative action. No doubt, the scope is very limited. The law is well settled that it is not open to the court under judicial review to examine the validity of the decision, but the court can examine the correctness of the decision-making process. The Honorable Supreme Court in the case of Kesavananda Bharati versus State of Kerala reported in 1973 4 SCC 225 has held that in such case, the court reviews the constitutionality of an administrative action and also examines its fairness and reasonableness and justness. The Honorable Supreme Court in the case of Tata Cellular versus Union of India reported in 1994 6 Supreme Court cases 651 has considered the applicability of Wednesbury principle of judicial review, and at paragraph 80 the said report has quoted the said principle which speaks for itself. At this stage, the Supreme Court practice 1993 volume 1 849850 may be quoted. Wednesbury principle, what it is. A decision of public authority will be liable to be quashed or otherwise dealt with by an appropriate order in judicial review proceedings where the court concludes that the decision is such that no authority properly directing itself the relevant law and acting reasonably and have reached it. Quoted from Associated Provincial Picture House Limited versus Westbury Corporation as per Lord Green, MR. Paragraph 77 of the said decision is apposite to the context as such is quoted. paragraph 77 of Tata Telestra. The duty of the court is to confine itself to the question of legality. Its concern should be whether the decision-making authority exceeds its power, committed an error, committed a breach of rules of natural justice, reached a decision which no reasonable tribunal would have reached for, or abuse of its power. Therefore, it is not for the court to determine whether a particular policy or particular decision taken in fulfillment of that policy is fair. It is only concerned with the manner in which those decisions have been taken. The extent of duty to act fairly will vary from case to case. Shortly put, the grounds upon which an administrative action is subject to control of judicial review can be classified as under legality. The means decision maker must understand correctly the law that regulates his decision making power and must give effect to it. Irrationality, namely when it's very unreasonableness. Procedural impropriety. The above are all the broad grounds, but it does not rule out addition of further grounds in course of time. As a matter of fact, in RV Secretary of State for the Home Department, ex-Brind, Lord Diplock refers specifically to one development, namely the possible recognition of the principle of proportionality. In all these cases, the test to be adopted is that the court should consider whether something has gone wrong of a nature and degree which requires the intervention. The Honorable Supreme Court, following the same principle in the case of Municipal Corporation, Municipal Council, Nimuk and Mahadev Real Estate and others, reported in 2019 10 Supreme Court cases to 738, has held that it is not permissible to the court to examine the validity of a decision, but the court can examine only the correctness of the decision-making process. Keeping such scope of judicial review in administrative action of the state in mind, let me now examine the issue under consideration. A plain reading of SOP clearly indicates that it prescribes a complete mechanism to get the service of SRs during the bond period smoothly and without any dispute. Therefore, it is not correct to say that the said document contemplates two distinct aspects, that is counseling and posting, or the choice exercised during the counseling would not directly reflect in the posting. They say it would suffice to quote paragraph 7A of the SOP to understand the purport of the said document. Then 7A quoted, counseling based on merit list prepared on the basis of collected stated particulars. The SOP, without any ambiguity, prescribes that posting would be preceded by counseling based on merit. Obviously, such counseling is aimed to achieve the principle of fairness and transparency, as held by the Honorable Supreme Court in the case of Bhavna Tiwari Supra. In the present case, the state, following the mandate of the said SOP, has posted 869 out of 871 candidates in the hospitals opted by them at the time of counseling. But such mandate has not been followed in the posting of petitioner and another candidate. And in doing so, the state has compromised with the merit, inasmuch as Dr. Antara Danki, having merit rank 26, and Dr. Ripanna Chattopadhyay, having merit rank 34, have been posted in the hospital opted by them at the time of counseling, that is Arjikor Medical College, whereas the petitioner having merit rank 24 has been denied the posting in the said hospital, though opted at the time of counseling. The state has sought to interpret the phrase "if offered to me" appearing in the self-declaration of the petitioner to mean that it is the prerogative of the state to offer a seat unless such offer is made. The choice made in the counseling is not binding. This court is unable to accept such interpretation of the said phrase, as it would render the procedure prescribed under the said SOP in the matter of deployment of SRs nugatory. The logical interpretation of the said phrase should be that candidate must secure the merit position to get the offer according to his choice. The state sought to justify the said deviation from SOP also on the ground that the hospital where the petitioner has been posted has a higher requirement for SR in the relevant discipline than the hospital opted by the petitioner. The justification is too feeble inasmuch as the deviation, if necessary, should start from the last ranked candidate. The Honorable Supreme Court in the case of Asa Supra has held that higher competition, greater is the duty on the part of the authorities concerned to act with utmost caution to ensure transparency and fairness. It is one of their primary obligation to see that a candidate of higher merit is not denied seat to the appropriate course and college as per his preference. The state has not disputed that it is bound to follow the principle laid down by the United States Supreme Court in the case of William Vincent Vittorelli, but has refused to apply the said principle in the present case, alleging that the SOP, being an administrative instruction issued only to regulate the service of SRs during bond period, lacks the force of law, even of a regulation, as such not enforceable. The Constitution Bench of the Honorable Supreme Court in the case of Sukhdev Singh Supra has held that even if the regulations have not got the force of law, the principle laid down in William Vincent Vittorelli should govern this situation. Extracts from the paragraph 122 is quoted below for ready reference. Then 122 quoted. The SOP is a tool designed to achieve the right guaranteed under Article 14 of the Constitution. Even if the SOP is an administrative instruction, the state is bound to follow the ethos of Article 14 of the Constitution to eliminate arbitrariness in the state action. In the case of Dr. Amjit Singh Supra and Ramanna Dayaram Setti, the Honorable Supreme Court has laid down the principle that the nature of administrative instruction not having force of law, but the state government could not at its sweet will depart from it without rational justification. The said principle is equally applicable in the facts and circumstances of the present case. The Honorable Supreme Court in B.S. Minhas has laid down the administrative authority is bound to adhere to the procedural standards fixed by it to avoid arbitrariness, failing which the action taken by it would be invalid. The Honorable Supreme Court in the case of Darshit Singh Griwal has held that it is axiomatic that having enunciated a policy of general application and having communicated it to all concerned, the administration is bound by it. Of course, it can, of course, change the policy, but until that is done, is bound to adhere to it. The paragraph 14 of the said judgment is quoted below for ready reference. Paragraph 14 quoted. The decisions cited on behalf of the state are not applicable in the present case for the following reasons. An order of transfer is an incident of government service in the backdrop of the said settled position. The Honorable Supreme Court in the case of S.L. Abbas and in the case of Govardhan Lal has held that a transfer made even in transgression of administrative guideline cannot be interfered with, as they do not confer any legally enforceable right unless shown to be vitiated by malafide or made violation of a statutory provision. Those decisions are distinguishable in facts. The case of R. Sai Bharti, though is a factually distinguishable in as much as the matter relates to code of conduct issued by the state government under Article 162 of the Constitution for exercise of executive authority by minister. Nonetheless, the Honorable Supreme Court in the said decision has held that the good ethical behavior on the part of those who are in the power is the hallmark of good administration, and people in public life must perform duties in the spirit of public service rather than assuming power to indulge callous cupidity regardless of self-imposed discipline. In the case of G. Ratnam and others, while dealing with an issue whether a disciplinary proceeding initiated against a railway employee would be vitiated for not following the certain guidelines contained in the vigilance manual, the Honorable Supreme Court has held that such instructions do not have the force of statutory rules, as such do not confer any right on any member of the public to ask for a writ against the government by a petition under Article 226 of the Constitution. In contrast, the state by the SOP has not issued a mere administrative instruction to its servants. It lays down a complete procedure for engagement of doctors to get their service for the bond period. The state is following the said procedure for deploying a set of candidates, but is denying to follow it for two candidates only. The arbitrariness of the state in the said action is on the face of it, and as such, action offends Article 14 of the Constitution. In the case of Upananda Chatterjee, is no pointer to the issue under consideration. The decision of the Honorable Supreme Court in the case of Lohia properties is misplaced in the facts and circumstances of the present case, inasmuch as issue falls for consideration relates to pure question of law to be decided on the basis of undisputed facts. Therefore, doctrine of non-favors has no manner of application here. The petitioner has not made out a case of malafide. Therefore, the decision of the Supreme Court in the case of Ratnagiri and Power Limited has also no manner of application in the present case. Conclusion: summing up the discussion made above, this court holds the decision of the state to deploy petitioner at Raiganj Medical College and Hospital Uttar Dinajpur clearly violates the Wednesbury principle. Thereby, the state has committed a serious wrong which demands intervention. Accordingly, the issue is answered in affirmative. As a result, the impugned notification dated May 27, 25 and the list annexed thereto, so far those documents relate to the deployment of the petitioner at Raiganj Medical College and Hospital, Uttar Dinajpur, are set aside. The department is directed to deploy and or engage the petitioner in the second vacancy of the SR in the discipline of anesthesiology at RG Medical College with immediate effect.
Deeply obliged.
My lord, I'm praying for a stay of operation of this order, my lord, up to 7th of October, my lord, considering the fact that 3rd of October is the first date of the vacation bench, my lord. We will kindly record this.
Mr. Nag, learned advocate of the state, praise stay of after delivery of judgment. Mr. Nag, learned advocate for the state, praise stay of the operation of this order, judgment and order, at least till the 7th of
October, my lord.
October,
Considering that it is the ensuing Puja
October,
vacation and the first date is 3rd of
7th of October 2025.